This presentation will give you an overview of the main international legal sources on indigenous peoples' rights. First, ILO Convention 169 is a legally binding international instrument that focuses specifically on indigenous peoples' rights. It was issued in 1989 and has been ratified by over 20 countries. Some of the key purposes of this convention are to provide guidelines to identify who are indigenous peoples and recognize rights and special measures to protect them. For instance, the Convention establishes the right of the communities to determine their priorities and to participate in decision making over issues that could affect their lives, social institutions, beliefs, and spiritual well being. Please read about some of the main articles of ILO Convention 169. Second, the United Nations Declaration on the Rights of Indigenous Peoples was adopted by the UN in 2007. Although not legally binding, it establishes important political commitments of the signatory states towards the protection of indigenous peoples. For instance, the declaration develops one of the main international legal principles, which is the right to self-determination. This means that indigenous communities are entitled to self-government, to maintain their autonomous social, political, and cultural institutions, and to determine their destiny as a collectivity. Please read about some of the articles that relate to the right to self-determination in the Declaration. Third, the United Nations Special Rapporteur on Indigenous Peoples' Rights is appointed by the United Nations Commission on Human Rights. Among others, the rapporteur conducts thematic research, elaborates reports, and visits countries. The reports of the rapporteur are not legally binding, however, provide a complete framework of key issues related to indigenous peoples' rights, such as the administration of justice, educational systems, and the impact of large-scale development projects on the fundamental freedoms of indigenous peoples. In his scholarly work, James Anaya, former UN Special Rapporteur on Indigenous Peoples, has identified 5 elements within the principle of self-determination of indigenous peoples, which are non-discrimination, cultural integrity, lands and resources, social welfare and development, and self-government.
The mandate of the Special Rapporteur on the Rights of Indigenous Peoples was established in 2001 by the Commission on Human Rights, which is the predecessor to the current Human Rights Council, the intergovernmental body of the United Nations charged with promoting human rights throughout the world. The first mandate holder, the first person to be appointed to the mandate, was the distinguished Mexican anthropologist and sociologist Rodolfo Staffenhagen, and he held the mandate until 2008, and in that year I was named to the mandate. At that time, the Human Rights Council had replaced the Commission on Human Rights and amplified the mandate to incorporate references to the UN Declaration on the Rights of Indigenous Peoples, establishing, in my view, the Declaration on the Rights of Indigenous Peoples as an important point of reference for the work of the Special Rapporteur. And so I have, in my work as Special Rapporteur, seen the Declaration on the Rights of Indigenous Peoples as the principal normative framework for the work, so that in examining the situation of indigenous peoples around the world and writing reports and making recommendations about those situations, how to address violations of the human rights of indigenous peoples, I look to the Declaration to provide that the standard to be applied.
Finally, the Inter-American human rights system is based on its own regional instruments, as opposed to the other international sources, namely the American Declaration of the Rights and Duties of Man and the American Convention of Human Rights and other specialized conventions. The main sources applied by the system to protect indigenous peoples' rights are the American Convention articles on the right to life, Article 4, and the right to property, Article 21. Although these articles refer to individual rights which are applicable to all citizens in the Americas, judicial interpretations have expanded them to recognize indigenous peoples' rights, such as the right to collective property over their territories. The judicial recognition of special rights applicable only to indigenous peoples is explained on the next subsection of the course on indigenous peoples' rights in the Inter-American System. Please continue to the next subsection.